Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. Welcome back to our video series entitled DB's Wish List. Is it true that a seller rentback is subject to the governor's moratorium on evictions? Yes. The short answer is yes. Seller rentbacks post-closing, when seller retains possession of the property after closing, seller's occupancy is subject to the Landlord-Tenant Act, and it is also subject to the governor's moratorium on evictions. Of course, we're talking about the coronavirus pandemic, stay home, stay healthy orders, et cetera, et cetera. The governor imposed, if you're not already aware of it, imposed a moratorium on evictions prohibiting all residential landlords from delivering a notice of termination and proceeding with an eviction action against all residential tenants. And there's only 3 exceptions to this blanket prohibition, and those 3 exceptions deal with the tenant creating a dangerous circumstance, or, and here's the one that really is probably going to come into play in this scenario, the owner of the property wanting to take personal occupancy for themselves or their family members, or the owner of the property wanting to sell the property. In the context of this question, we're dealing most likely with a scenario where a buyer post-closing who has a seller who retained possession at closing and now won't leave, the buyer is likely only to be able to get that seller out of the property by triggering the exception to the moratorium on evictions that allows the owner of the property to serve a notice based on the owner's desire to take personal occupancy and then evict the tenant. That notice is a 60-day notice. Following delivery and expiration of those 60 days, then buyer can start the actual process of evicting and removing the seller/tenant from the property. Buyer is going to be paying legal fees for that assistance. I can't tell you as I stand here before you what that 60-day notice has to say. The governor's moratorium does not specify the language that's required in a notice. The governor's moratorium does not specify the manner in which that 60-day notice must be delivered. And there's debate in the legal community as to both issues. So, said differently, brokers, you cannot assist your buyers with this effort. If you have a buyer post-closing who's got a seller who won't vacate, that buyer must seek legal counsel. They must have their lawyer assist them with preparing the notice, delivering the notice, and then, of course, managing the eviction process. The governor's moratorium currently runs through October 15th. We have every expectation that it will be extended. Buyer brokers, here is the takeaway summary of the answer to this question. If you have a buyer who is considering granting post-closing possession rights to the seller, caution them as to the risk, advise them to seek legal counsel, and put both of those in writing. Your warning of the risk, your advice to seek legal counsel, put both of those pieces of information in writing, and make sure that you have a way that you can prove delivery of that written information to the buyer post-closing. Because if the worst case scenario comes to pass and the seller won't move and the buyer is stuck with the seller in their new home, it is going to be emotionally, mentally, time, and financially consuming, maybe devastating to your buyer. And you need to make sure that you can prove that you warned the buyer of the risk and advised them to seek legal counsel. This is a big deal. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.